A court case has been launched against the federal government seeking equal access to the age pension for Aboriginal and Torres Strait Islander people. A Wakka Wakka man is bringing the case with support from the Victorian Aboriginal Legal Service and the Human Rights Law Centre. At the heart of the case is his assertion that the government has failed to close the gap in life expectancy between Aboriginal and Torres Strait Islander people and non-Indigenous people in Australia. Joining me now is Meena Singh, Senior Advisor to the Human Rights Law Centre. Welcome to the program.
Thank you for having me.
Can you just detail the nuts and bolts of this case for those who haven't been following along with the news the last couple of days?
Of course. So at the heart of the case is fairness. It's about equity of outcome and seeking to allow Aboriginal and Torres Strait Islander people as elders to access the age pension at an earlier age. So what we're doing is we're asking the federal court to use the Racial Discrimination Act in such a way as to read the Social Security Act and the sections that deal with age pension eligibility, and to say that because of the gap of life expectancy for Aboriginal and Torres Strait Islander people compared to non-Aboriginal and Torres Strait Islander people, that community should be able to access the age pension earlier than the eligibility age.
And that gap at the moment averages about 10 years. So is the principle here, when you talk about that fairness, that there's a whole decade that Aboriginal and Torres Strait Islander people simply don't have access to that whatever every other Australian has access to?
Well, the idea is that, from decades of different policies and laws that have entrenched disadvantage for Aboriginal people. And we're talking about people who've experienced things such as stolen wages, such as being a member of the stolen generation or having other family members or living in fear of becoming a member of the stolen generation. People who've had really hard lives. And, when we look at Aboriginal and Torres Strait Islander communities, we see high rates of suicide, we see the impact of Aboriginal deaths in custody, we see high rates of disability and chronic illness. And all these factors come together to create shorter life expectancies for our community. So this case is really talking about, okay, once Aboriginal and Torres Strait Islander people get older, they don't get to enjoy their elder years in the same way that non-Aboriginal and Torres Strait Islander people do, because they simply don't live as long. So what we're saying is that that rather than thinking about treating everyone exactly the same, we need to think about the life experiences that Aboriginal and Torres Strait Islander people have had, what their quality of life is like as they get older, if they indeed get older, and think about what is the best way that we can support them. And one of those ways is with earlier access to the age pension.
Tell me about the Wakka Wakka man at the centre of this who has brought this action.
Uncle Dennis is an amazing individual. He's very well known in the Victorian community. He has been on 3KND, the radio station for Aboriginal community, for years. And he grew up in Cherbourg, which was an Aboriginal mission originally in Queensland. He's worked since the age of 10, and he's experienced, working as a child and then having his wages stolen. He's been part of settlement claims that have been around, stolen wages by the government in Queensland. He's an amazing individual. He's right now working 2 jobs. He is bringing this case not so much for himself as it is for other people who may be working far beyond what their bodies will allow them to, simply because they are unable to access a pension at an appropriate age.
And Uncle Dennis featured in a report by my colleague at the ABC's Indigenous Affairs editor, Bridget Brennan, that was on the news and everywhere yesterday, if you want to catch up on that as well. Is this case depending on other legal cases as precedent, or is this really a test case?
It's really a test case. We're looking at Section 10 of the Racial Discrimination Act, and that talks about one race, one group of people who have lesser enjoyment to a right than another group of people. So whilst we can say that once everyone reaches a certain age, they're eligible for the age pension, considering their assets, what we're saying is that not everyone comes to that same age with the same experiences. And specifically for Aboriginal and Torres Strait Islander people, there's been decades of discriminatory policies and legislation that has created these negative health outcomes for Aboriginal people.
And what's been the community reaction? Because certainly there's been a lot of discussion overnight about this case. I wonder if there's a sense of whether there might be others who want to get on board with this as well.
There's been a lot of positive response from the community. Aboriginal people, we're very proud, especially our elders, but we want to see them be able to receive an age pension in response to a life of hard work, a life that has been lived before the 1967 referendum, lives that have experienced segregation and exclusion. And so, we want to be able to support our elders as they get older.
There's a school of thought, Meena Singh, that the courts are taking a view on the role of Australia in protecting and nurturing Aboriginal and Torres Strait Islander people. There's the Timber Creek case. There have been a number of High Court attempts related to mining in Western Australia. There's even been a change in who can be considered an Australian citizen based on Aboriginality as yet. Do you have a sense that the courts are stepping into this arena?
I think it depends on the circumstances. I think we're starting to develop our ideas of fairness and realising that not everyone comes to the law having had equal experiences, and it's not necessarily going to guarantee equity of outcome if we just treat everybody the same. Where I think the courts are really starting to understand how the impact of invasion and colonisation on an ongoing level has really led to drastically different outcomes for Aboriginal and Torres Strait Islander people. So they're the sort of sentiments we want to see the court considering in this case.
Quite often, one of the challenges with the courts is that they can take so very long to make a decision, and of course the landmark Mabo case was handed down after Uncle Eddie Koiki Mabo passed away. How long do you expect this case to take?
Well, like you said, these cases can take a long time. It really depends on how the federal government responds and how they want to consider what is fairness in this case. And, this is a really quite straightforward, simple measure. At the moment of people receiving age pension, less than 1% of them are Aboriginal and Torres Strait Islander. So we're not talking about a massive amount of people, but we're talking about a move that can really result in dignity and security of economic life.
What do you think the likelihood is of the government avoiding a court case and simply saying, well, actually, maybe this is a change we can make?
That would be wonderful. We're seeing, the government, with close the gap measures, investing a lot of money and resources into closing the gap. Those measures take time to see the rewards of. But this is something that can be done now that can really create a difference in people's lives.
And look, just finally, we've just touched on the courts and perhaps a bit of a change there. There seems to me to be an appetite from the general Australian population to have a greater impact and to be offering greater support to First Nations people. Is that something that you're seeing?
I do see it, but I think there's lots more work to be done. There's lots more engagement with the community and that's required, and a lot more of listening to be done to hear actually the stories and how these experiences have played out and how disadvantage plays out through different generations. But I think more and more we're having people willing to listen and willing to enter into discussions about what is fairness and what is equality of outcome.
I know I did say last question, but I just want to hold you here as long as I can. And while I've got the floor, we were having a national discussion about truth-telling and about how we reconcile these very difficult conversations right now. How does that fit in with this case and what you're trying to do?
Absolutely. Truth-telling is so incredibly important, as well as what we do in response to that truth-telling. Truth-telling is only one part of the story. We need to then create responses and actions that address the disadvantage of outcomes that Aboriginal people experience. And for someone like Uncle Dennis, what he represents is a generation of people who have, experienced life being excluded from the broader Australian narrative. When we think about Australia, we don't necessarily see how much has been provided for non-Aboriginal people as much as has been taken away from Aboriginal people. So I think we're in a space where we're really willing to understand just how much of an impact past denial of rights has now, and that it's not just a matter of now we'll treat everyone equally and that should be okay. We really need to think about how people come to the law.
Yeah, we will have to leave it there. So grateful for your time. Senior Advisor of the Human Rights Law Centre, Meena Singh. Thank you so much.
Thank you.